Good morning, this is your Kelso Report for Friday, November 30th, and I'm your host, Clark Kelso. Well, our first case today is from the California Supreme Court and involves the law regarding conversion of mobile home parks from resident tenant parks to resident owners. And then we have a California Court of Appeal decision involving deeds of trust and foreclosure, and a second Court of Appeal decision involving the definition of a switchblade. We begin with the California Supreme Court. Land use regulation in California is a complex web of local and state land use and environmental laws, and the attempt to develop property quite often implicates the full web of those laws. In Pacific Palisades versus City of Los Angeles, the owner of a mobile home park wanted to convert it from rental tenant occupancy to resident ownership, a conversion that did not involve any change in the density or intensity of the property's use. The property owner followed the procedure for mobile home conversion set forth in the State Subdivision Map Act, but the city refused to grant the necessary approvals because the owner had not submitted the written documentation necessary to comply with the Coastal Act and the Mellow Act, acts that apply to developments. Well, the property owner argued that the specific provisions within the Subdivision Map Act pertaining to mobile home conversions displaced the Coastal and Mellow Acts, but the California Supreme Court disagreed with this argument. The court held that Government Code Section 66427.5, which states a uniform statewide procedure for protecting non-purchasing residents against economic displacement during a conversion of a mobile home to resident ownership, was not intended to exempt those conversions from the independent requirements of the Coastal Act or the Mellow Act, which also apply to such conversions. The policies underlying the Coastal and Mellow Acts are too important to be so easily displaced by one ambiguous provision in the Subdivision Map Act. Accordingly, local agencies like the City of Los Angeles are not precluded from establishing procedures and holding hearings that are appropriate to fulfill their responsibilities to ensure compliance with the Coastal Act and the Mellow Act, which is what the City of Los Angeles was attempting to do. So that conversion is going to have to wait until they go through the full application process for getting approval for developments under the Coastal Act and the Mellow Act. Nothing is easy in California. Next, we have a case involving property law and foreclosure. Now, with the number of foreclosures that are occurring in the last several years, we are seeing quite a few appeals exploring every nook and cranny of the foreclosure law. In Schuster versus BAC Home Loan Servicing, the 2nd District faced a question of first impression in California, and it adopted the rule that is followed in the most other jurisdictions on this issue. The facts were that the appellants had borrowed $670,000 to purchase a home, but the deed of trust securing the loan did not name a trustee. This was clearly a technical violation. When the appellants fell more than $90,000 behind in payments, the beneficiary of the deed of trust substituted a company as trustee to initiate non-judicial foreclosure proceedings. While the appellants challenged the foreclosure sale on the ground that the omission of the trustee on the deed of trust essentially converted that instrument into a mortgage, which can be foreclosed only by a judicial foreclosure sale. The 2nd District rejected this overly technical and formalistic analysis, holding that the omission of the trustee's name on the deed of trust did not preclude non-judicial foreclosure of the deed of trust. Seems to me it's a very practical and sensible conclusion that effectuates the likely intention of the parties to the transaction, given that the buyers had fallen so far behind. They obviously were trying to take advantage of every technicality they could. The court rejected that attempt. Lastly today, we look at the definition of a switchblade. Now, the law delights in fine distinctions, and the 4th District in In re Gilbert R. was called upon to make such a fine distinction, to determine whether the juvenile before the court was in the possession of an illegal switchblade knife, or, alternatively, was in possession of a legal knife that, in the hands of an expert, happens to behave an awful lot like a switchblade knife. Well, ultimately, it came down to a matter of statutory interpretation. Section 17-235 of the Penal Code defines a switchblade knife as, quote, a knife having the appearance of a pocket knife and includes a spring blade knife, snap blade knife, gravity knife, or any other similar type knife, the blade or blades of which are 2 or more inches in length and which can be released automatically by a flick of a button, pressure on the handle, flip of the wrist, or other mechanical device, or is released by the weight of the blade or by any type of mechanism whatsoever, close quote. Well, the switchblade in our case could be opened by someone experienced in handling the knife simply by the flick of a wrist. So the juvenile court thought the statute had been violated. But the statute also contains an exemption for, quote, a knife that opens with one hand utilizing thumb pressure applied solely to the blade of the knife or a thumb stud attached to the blade, provided that the knife has a detent or other mechanism that provides resistance that must be overcome in opening the blade, or that biases the blade back towards its closed position, close quote. Well, the knife in our case did indeed have a detent and a thumb stud. So for the 4th District, the exemption plainly applied, even though the knife could also be opened by a flip of the wrist. So, next time you go shopping for a switchblade, make sure it has a detent that provides resistance that must be overcome in opening the blade. And that'll keep you on the legal side of things. That's it for today's Kelso Report. Have a great day in the law.